Good morning, and thank you for joining us today. I'm Charles Cabell, partner and chair of our education practice here at Williams Mullen, and serving as your host for today's webinar. I'm joined by two Williams Mullen colleagues in Richmond today. Nelson Wilkinson, a partner in our labor and employment practice and stalwart member of our educational group, and Daniel Watkins, an attorney in our litigation practice, who also bolsters our educational group. Before we get started, we've got a couple of housekeeping notes. First, we encourage you to ask questions throughout the program using the chat feature on the upper left corner of your screen. We will answer them at the end of our presentation. And lastly, we request that you place your cell phones away from your landlines so as to minimize audio interference. Throughout the next 60 minutes, we're going to address two topics. We're going to start with the legal analysis of campus sexual assault briefing. And as you are aware, the Virginia legislature has passed 3 new laws which have now been signed by the governors. And these laws address how colleges must report and address incident of sexual assault on campus. These laws become effective July 1st, and Nelson Wilkinson will discuss what these laws mean for the schools in the Commonwealth and what you should be doing to prepare for when they become active. So Nelson, let's begin.
All right, thank you, Charles. As Charles mentioned a moment ago, I'll be discussing 3 recent bills. I call them bills, although they're now officially laws, addressing reporting and recording of sexual assaults that occur on campus. These laws were prompted in large part by the Heather Graham case at UVA, the tragic murder of the student there, by an individual who had been involved in sexual assault at another university, and those records had not been transferred, and it had not been reported to the police. And the thought was that if it was required to report these incidents to police, it might have prevented that murder. So it went through sort of a tortuous process in the legislature, and these are the bills that ultimately resulted. Some of you may have heard of earlier versions of the bills. They were changed in some significant ways since what was originally reported. Now, these laws have not gone into effect yet. They will go into effect on July 1st. And so there's no case law interpreting them yet, but so all we have to go on is the text of the laws themselves. So what we're going to be focusing on is what is actually required of schools under these new laws. So again, there were 3 bills. One was HB 1930, which involves the reporting of sexual violence by the school. SB 1193, which in some ways may be the most problematic of the 3, and that involves the recording of sexual violence discipline in the student transcript records. And then HB 1785, which involves the reporting by campus police to local law enforcement. So the first of them is the first we'll be discussing is HB 1930. There's a number of aspects to this law. First, the school must ensure that certain employees report sexual assaults as soon as practicable to their Title IX coordinator. They must form a review committee. They have to ensure that that review committee meets within 72 hours of receipt of information. They must immediately make a report to police in certain emergency situations, as well as notify the victim. Ensure appropriate committee member makes a report to the Commonwealth attorney within 24 hours of learning of an alleged felony sexual assault. Schools will have to establish an MOU with local sexual assault center. They'll have to adopt policies for providing specific information to victims regarding sexual assault crisis centers. And finally, they'll have to review and certify their policies on these topics annually. Under SB 1193, the school must ensure that the registrar notes sexual assault violations on student transcripts and ensure that certain notations regarding suspensions are removed when the suspension ends. And then the third, the school must amend or enter into MOUs with law enforcement or campus police, requiring them to report felony sexual assaults to the Commonwealth attorney within 48 hours of beginning an investigation. So those are the basic requirements, but there's a lot of subtle and less subtle ramifications and caveats. So we'll be going over each of those in more details to hopefully give the audience an idea of what exactly is going to be required of them in practice. So HB 1930 we'll be discussing first. Again, this is the one regarding the schools reporting of sexual assaults. The core provision says that any responsible employee who in the course of his employment obtains information that an act of sexual violence may have been committed against a student attending the institution or may have occurred on campus, in or on a non-campus building or property, or on public property, shall report such information to the Title IX coordinator as soon as practicable after addressing the immediate needs of the victim. Now, people with experience reading statutes will recognize that a lot of the terms here are a bit loaded or just raise further questions. We've highlighted those and we'll go over them. The first question is, who is a responsible employee? The statute defines it as a person employed by a public institution of higher education or private nonprofit institution of higher education who has the authority to take action to redress sexual violence, who has been given the duty of reporting acts of sexual violence or any other misconduct by students to the Title IX coordinator or other appropriate institution designee, or whom a student could reasonably believe has this authority or duty. Some of you may recognize there's a similar standard under Title IX for when a duty to institute an investigation is triggered. The general advice here is the schools want to designate responsible employees in writing, if possible, in the handbook or by other notice to the students, so that the student body is aware of who they can make these reports to, or who is going to be the responsible employee who is going to forward it to the appropriate Title IX coordinator or other higher-ups within the university. Obviously, by doing so, that's going to require that those designated individuals be properly trained to know when they are receiving the kind of report that they need to escalate and what to do when that happens. And if you look carefully at the text, it says who has been given the duty of reporting acts of sexual violence or any other misconduct. So that is something to be careful about. You can't just designate if someone is designated as being someone who any kind of misconduct, whether it be drinking or any other non-sexual assault violence, they are also going to have the duty of making reports regarding sexual violence. So that, again, is a training issue. And then finally, they have the catch-all, whom a student could reasonably believe has this authority or duty. Again, this is someone who, it's sort of a catch-all, and it raises questions, for example, with respect to resident advisors. And again, that may or may not be someone who the student reasonably believes that they could bring these reports to. Now, interestingly, this section contains a qualified defamation privilege. It's not up there on the screen, but whoever makes these reports is protected from a defamation lawsuit as long as the report isn't brought in bad faith. So the next requirement for the reportee or the employee designated as someone who can make these reports is that they receive the complaint in the course of his employment. Now, again, this is pretty broad, so the school should not assume that understand that you have a hard time hearing. I'll try to get closer to the microphone. Someone who is going to be in the course of their employment, if they're reasonably related to their duties. Even if they're off campus, it's likely still in the course of their employment. If they're somewhere where they're meeting students, it doesn't matter if it's outside of their hours. Generally, this is a broad standard, and when in doubt, the person receiving the report should err on the side of assuming that when they receive it, they are in the course of their employment. And again, this is most tricky in the case of resident advisors whose duties and role as sort of a student themselves may blur. But again, it behooves the school to err on the side of assuming they are. Now, a question I receive often in the Title IX context is when reports are raised in certain contexts where the student might have an expectation of privacy. And the legislators had this in mind, and so they crafted certain exceptions for situations where even if the person would otherwise be a responsible employee, they do not have to escalate the report to the Title IX. That's one where the responsible employee is the victim himself or herself. If it was otherwise privileged, importantly, if the otherwise responsible employee is a professional counselor, someone who's in a rape crisis center, of course, or a campus victim support personnel generally, a school clergy, an attorney. And then finally, they say that the responsible employee does not have to report it to Title IX if they have actual knowledge that it's already been reported. Now, actual knowledge is a fairly high standard, higher than constructive knowledge. So the people who may be receiving these reports on campus should be trained to never assume that the report has already been brought to the Title IX coordinator. Again, they're always going to, unless they know for a fact that that is the case, they want to err on the side of making the report, even if it turns out to be redundant. All right, so the duty to make this report to the Title IX coordinator is triggered when the responsible employee obtains information that an act of sexual violence may have been committed. Again, that raises the question of what is the definition of sexual violence under this law. It is a physical sexual act perpetrated against a person's will or where a person is incapable of giving consent. So note that the definition here is a physical act. So whereas Title IX encompasses verbal harassment of various kinds, and certainly that is still something a school is going to have to address, it is not covered by this new reporting law. And then, of course, you see the phrase incapable of giving consent. This is a phrase that comes up again in Title IX. It's one that schools have been struggling with across the country about where to set the appropriate standard. That is obviously not going to be solved by this law, and it's still going to continue to be an issue under it. All right, so what crimes of sexual violence must be reported? It must be reported if that act of sexual violence was committed against a student attending the institution or may have occurred on campus, in or on a non-campus building or property, or on public property. Now, notably, the law requires reporting if the act of sexual violence was against a student, regardless of where it occurs. So if it's a student and it's at a restaurant that was far off campus, and a responsible employee learns of that, they do have to report it. Now, that is not true if the accused is a student. be reported if it occurred on campus or in the non-campus building, et cetera. The definition of campus, these are imported directly from Title IX, so again, those who are familiar with the standards under that law will be familiar with these definitions, but the definition of campus is any building owned or controlled by the institution, as well as areas reasonably next to those areas that they control. The next is a non-campus building or property, which includes student organizations officially recognized by an institution. The main intent here is fraternities, clearly a place where sexual assaults may occur. A difficult issue occurs under this definition is when is there a duty to report sexual assaults that might occur on a satellite campus, a foreign campus, even a dorm where the institution has exchange students. And that's going to turn on the degree of control, as under the Clery Act. It's the degree of control that the institution has over the location. So if it's students studying abroad and they are taking care of their own accommodations, et cetera, it's pretty clear that that would not be an area where it would trigger a reporting requirement if the sexual assault occurred there. However, in cases where the school takes high degree of control, for example, they take over a wing of a dorm at a sister college in another state, for example, they may exercise the amount of control that would put it under this definition. And then finally, public property doesn't mean any public property. It's generally the sidewalks, streets, parking facilities that connect to the areas that are included in the other definitions. All right, who does the responsible employees report go to? It goes in the first instance to the Title IX coordinator. So the responsible employee is not required to go directly to the police. They only have to bring it to the Title IX coordinator, and as we'll see later, that Title IX coordinator, together with the review committee, will decide whether or not to escalate it to the police. Every school should already have a Title IX coordinator. It's a little bit odd. This is a state law incorporating a federal definition, but they drafted it that way to take advantage of the experience, the presumed experience of the school's Title IX coordinator. All right, the responsible employee has to make the report to the Title IX coordinator as soon as practicable after addressing the immediate needs of the victim. These aren't terms of art, at least not yet. They just mean that, clearly the responsible employee shouldn't be worried about trying to call someone before addressing the immediate medical needs of the victim, et cetera. So any responsible employees of the school should be trained accordingly. All right, the second major aspect of this new law is the review committee. So upon receipt of information pursuant to subsection B, the Title IX coordinator or his designee shall promptly report the information, including any personally identifiable information, to a review committee established pursuant to Section D. Nothing in this section shall prevent the Title IX coordinator or responsible employee from providing the information to law enforcement with the consent of the victim. Now, that last clause would seem rather benign on the face of it. I mean, of course, if the victim consents to informing the police, you would be able to inform the police. But sort of the flip side, although the statute never says this explicitly, the implied flip side of that statement is that this law is going to require some reports to the police without the consent of the victim. And that's the sort of implied meaning of that second phrase. So obviously for the review committee to receive these reports, the school has to have a review committee. So the law does, in subsection D, does require that each institution shall establish a review committee for the purposes of reviewing information or basically assessing these reports that are coming up from the responsible employee. And this review committee is going to determine whether it's the kind of report they have to escalate to the police or to the Commonwealth's attorney, which of those to report it to, et cetera. Now, the law does not say that this review committee has to be the body that actually adjudicates whether or not the accused is guilty of this complaint. The schools can keep their procedures in those regards. Now, the review committee could do that, but the law does not require that. The sole purpose of the review committee is deciding when to escalate the report to the police or Commonwealth's attorney. But of course, Title IX has its own investigation and review timelines. This law has different timelines, and it's important not to confuse those. So who is on this review committee? It has to be 3 or more persons. One is the Title IX coordinator or their designee. Because there's strict timelines, the Title IX coordinator may not be able to attend every committee meeting. A representative of law enforcement, and that can be a representative of campus security, and a student affairs representative. Now, student affairs representative is not defined. It's likely going to be a dean or a comparable official. It's probably recommended that it not be an actual student because of FERPA concerns and other issues. Although it doesn't prohibit it from being a student explicitly, it's probably a better idea that it be a faculty representative of the student. Now, if there's any public schools officials in the attendance, there's certain caveats to this that apply only to public schools. Public schools with Section 23-232, police forces, they should be familiar with that section, must use a representative from that police force as the law enforcement representative. And public colleges who are already required to form violence prevention or threat assessment committees, and those threat assessment committees can also constitute the review committee. Okay, what investigative and discovery authority do these review committees have? So the review committee may obtain law enforcement records, criminal history record information, health records, et cetera, and it cites these other laws, and these are the laws, these are separate Virginia codes on the dissemination of criminal history and juvenile record information, health records privacy, and one of the questions I've received from some schools regarding this is whether this new Virginia law expands their authority to get these records. I do not read it as expanding their authority. This section incorporates these already existing laws, which has their own provisions about when you can get these records, when you can't, and the language in the bill says they may obtain these records. And of course, it has to do so in compliance with federal privacy laws. And what it refers to there in compliance with federal privacy laws is likely referring to FERPA. And as we'll see in a moment, sections of this law seem to have been drafted specifically with FERPA in mind. So the school will inform the review committee, and when it receives the report from the responsible employee and the Title IX coordinator, it has to convene within 72 hours, and then it has to reconvene again as new information becomes available. One question I've received is, does the review committee have to convene within 72 hours of the sexual assault occurring or upon the responsible employee's receipt of the complaint? It's not clear, but as a practical matter, it can't convene until it knows about the information, so I would read it as within 72 hours of receiving the report. Okay, in certain emergency situations, the review committee must, quote, immediately report to police as well as notify the victim. What constitutes an emergency situation is the same definition under the FERPA regs. A question I get a lot is, does FERPA have an automatic exception that allows schools to make reports to police? It does not. Even under FERPA, a school can only make reports to police in certain emergency situations as defined in that act and also as incorporated here. And if you make the report in a non-emergency situation, it's possible that you are violating FERPA. Upon making that report, the school does have to notify the victim. Now, what's interesting about this report is, if you look carefully at the prior section of the law, the complaint of the sexual assault could be escalated up to this review committee and potentially to the police without the victim ever knowing about it. In other words, the initial reports to the responsible employee could come from someone who was not the victim but a witness. So it's entirely possible that this requirement that the review committee notify the victim is the first time the victim ever learns that a report has been made involving him or her. Now, late in the drafting of this law, people raised the issue of, well, if we report to the local law enforcement in certain countries, they may not have the same standards here in the United States, and even in certain countries, it could result in the victim getting criminal prosecutions. In other words, in certain countries where they may be more inclined to blame the woman when when a rape has occurred, for example. And as a result of them contemplating that problem, they added this provision in here that says that they'll not have to make that report to the police if the sexual violence occurs outside the United States. And that doesn't just include countries where you think that such a requirement would be a problem for women, because they couldn't really distinguish them that way. So anywhere outside of the police, outside of the United States rather, there is no requirement to escalate to the police. In the case of felony assaults, the rule is a little different. You do not necessarily have to go to the police, although certainly a felony assault may also be an emergency where you would have to go to the police. But in the case of a felony assault, you automatically will have to make the report to the Commonwealth's attorney. Interestingly, the campus security representative on the review committee sort of has veto authority over the other officials, and if he or she determines that it's a felony, he can make that report unilaterally. And then the review committee has an obligation to maintain the records and possibly do further investigation. I'm going to go quickly through the rest of the provisions under 1930 so that we can get to the notification law, which I think is most problematic. But suffice to say, the school also has to establish an MOU with the local sexual assault crisis center. That's a memorandum of understanding that's going to address how they deal with these situations when they come up. I won't read these here, but the victims must be informed of 8 specific bits of information when these events occur, and those include, resources to help them. Then, of course, the schools must review and certify their sexual assault policies annually. All right, so SB 1193, I think this law is the one that I've been hearing more agitas about from schools and colleges, even more so than the reporting requirements under the prior law. And I've talked to some of the sponsors of this bill, and they'll be the first to admit that the language is probably going to need additional tweaking as these schools try to apply it in practice. But under this law, the schools must ensure that the registrar note sexual violence discipline on the transcript and remove those notations if it's for a suspension after that suspension expires. Now, who is responsible? It's the registrar or whoever maintains the records at the school. And what must be noted on the student transcript? Well, the school has to make a notation when the student has been suspended for, has been permanently dismissed for, or withdraws from the institution while under investigation for an offense involving sexual violence. Now, clearly that last provision is somewhat problematic. I mean, for example, it's possible that someone may resign without knowing that they are under investigation, potentially. They could have to resign for other reasons. And as we'll see in a moment, the consequences of this are quite significant. So how must it be noted? The registrar must make a prominent notation on the academic transcript stating that such student was suspended for, was permanently dismissed for, or withdrew from the institution while under investigation for an offense involving sexual violence. Now, it goes on to provide an example, and it says, such notation shall be substantially in the following form. And it says, suspended, dismissed, or withdrew while under investigation for a violation of, quote, insert name of institution's code, rules, or set of standards. Now, there's a bit of a discrepancy in this law between these two sections. There was a lot of back and forth in the drafting of this bill over whether they're going to require these notations just for sexual assaults or for any violation of the school's code for any offense. You know, in other words, including drinking offenses, for example, honor code offenses. Ultimately, it appears they resolved that in favor of only requiring notations related to sexual violence. However, when you look at the example they give in the text of the statute itself, it still says for a violation of insert name of institution's code, rules, or set of standards. So it's a bit inconsistent there. It's not clear how exactly you're supposed to make these notations. For example, there may be kinds of sexual violence which may not be specifically addressed in the institution's code. So there is a bit of a discrepancy in how the law currently reads. Now, the student for whom you're making this notation has to be notified. Now, another major issue in the drafting of this bill is when is this notification removed from the transcript? The governor had made a recommendation that these notifications would be automatically removed after, I think, 3 years. But that recommendation was rejected. As it currently reads, there is no automatic removal of the transcript. It can be a permanent scarlet letter, if you will, that's going to remain on these students' transcripts potentially indefinitely. The only time that the institution is required to remove the notation is if the notation was regarding a suspension and the suspension has been completed and the school has determined that it's a student in good standing according to the institution's codes. But otherwise, the transcript is permanent. Which is, again, this is one that I've heard a lot of consternation or at least questions from schools regarding how this is going to work in practice. It may, for example, have the unintended consequence of making schools less willing to discipline people for sexual assaults, knowing that, if they get it wrong, it's going to result in this sort of permanent black mark, which the school can then become potentially liable, subject to a lawsuit from that student. I do think it is problematic in that regard. Again, this is only applies to schools in the Commonwealth, and interestingly, for whatever reason, VMI is exempted. I think that's probably explained by some last-minute lobbying or just to get the bill passed. All right, and finally is HB 1785. This is the simplest of the three, and it's similar to the first bill, but it requires that law enforcement officials who receive the complaints in the first instance must make the report to the police themselves if they determine that it constitutes a felony sexual assault. And then schools will have to enter into MOUs with the local police forces to ensure that that happens. We're going to take questions now or at the very end? Okay. So we'll take questions on this at the very end after the second part of our presentation.
Okay, our second topic today will be presented by Daniel Watkins and addresses campus misconduct in the law, best practices for the adjudication of student code violations. Let me turn it over to Daniel.
Thank you. Before I begin, I'd like to give a little background. I'm a second year, as Charles said earlier, second year litigation associate here at Williams Mullen. I have represented a number of college students who are facing criminal charges, and as a result of that representation, I have advocated for several of them during student misconduct proceedings in various colleges throughout the Commonwealth. I attended law school at the University of Virginia, and while there, I was involved as an advocate in several student misconduct hearings as well as honor proceedings. And even before that, I attended Abilene Christian University in West Texas, a small private school, where I worked for the general counsel and helped develop our student misconduct adjudication process. So I've worked in this area for several years, and I really enjoy not only working with universities to figure out the best practices that comply with state and federal laws, but also figuring out good outcomes that make sure that each institution's mission is being met through this student misconduct adjudication. I have three broad caveats that I'd like to share prior to beginning. My presentation discusses student misconduct, and that exempts sexual misconduct as well as academic integrity issues. Both of those areas come with a plethora of unique rules and differing legal standards, and I really wanted to focus on student misconduct. Finally, public universities as an arm of the government have to follow certain constitutionally required standards when they set rules for disciplining students. Typically, private colleges or universities are free within very wide guidelines and boundaries that are established by state law to set their own rules and to formulate their own disciplinary procedures. The idea behind that is a student is free to take or not to take such procedures into account when they decide to attend a private institution. However, once private schools establish and publish their disciplinary rules, the institutions are required by principles of contract law to follow them in good faith, even if not always to the strict letter. So with those three caveats in mind, let's begin. There is no constitutional right to higher education in the United States. The Supreme Court has not ruled that college attendance is a right. And although there is a baseline of constitutional protections, the rights vested typically involve contract rights rather than constitutional rights. And this is where developing a comprehensive and well thought out student handbook and code of conduct is very important. In Goss v. Lopez, the Supreme Court ruled that due process is required prior to substantial sanctions based on student misconduct. In that case, the Supreme Court set forth the following minimum requirements for the provisions of due process. The first is oral or written notice of the charges. The second is an explanation of the evidence if the student denies the charges. And the third is an opportunity to present, an opportunity for the student to present her side of the story. The Goss case involved 9 students at 2 high schools and 1 junior high school in Columbus, Ohio. The students were involved in fights in the cafeteria. I believe there was some graffiti and property damage, and the school principals did not hold hearings for the students who were accused, in part because the administrators personally observed the misconduct. Ohio law didn't require hearings prior to suspension, but the students challenged the principal's actions, and the federal court, district court, found that the students' rights had been violated. The case was appealed to the Supreme Court, and the question before the justices was, did the imposition of the suspensions without preliminary hearings violate the students' due process rights guaranteed by the 14th Amendment? In a 5-4 decision, the court held that because Ohio had chosen to extend the right to an education to its citizens, it could not withdraw that right on grounds of misconduct, absent fundamentally fair procedures to determine whether the misconduct had indeed occurred. Although this case took place in the context of secondary school, federal courts have applied the same rationale to hold higher education institutions accountable to the protections found in their student handbooks. And again, I'd like to iterate that developing a good student handbook and outlining the student code of conduct is very important. Okay, let's go to the constitutional protections. Before depriving an established right, the 14th Amendment requires that accused students be afforded a minimum threshold of due process. It's not typical for these cases when they're taken to court to reach the circuit court level, but one of the landmark cases is Dixon v. Alabama, which actually made it to the Fifth Circuit in 1961. Importantly, the Dixon case involved several civil rights activists who took place in demonstrations, protests, sit-ins, etc., to protest Jim Crow. In the Dixon case, the students the student was from Alabama State College, and which was a segregated black college, and after 6 students engaged in this civil disobedience, the college expelled the students, but they didn't really provide any reasons for the expulsion. So in Dixon, the court ended the doctrine that colleges and universities could act in loco parentis to discipline and expel their students. It's really the leading case on due process for students in public higher education. The 2 principles afforded in Dixon are that due process requires adequate notice of the accused students and a hearing that comports with fundamental fairness. We're going to get into those 2 prongs separately. First, we'll start on adequate notice. The Supreme Court describes this notice requirement as elementary and fundamental to due process in any proceeding which is to be accorded finality. This notice is primarily designed to apprise interested parties of the action against them and afford an opportunity to present their objections. Now, at the crux of this notice requirement is to let the accused student know what exactly interest, which interest exactly may be deprived, so the accused student can adequately prepare and take steps to protect these interests that are in jeopardy. And from a practical standpoint, we usually think of notice as well in advance to any hearing, but that's not really how the courts have interpreted this requirement. In fact, in a case against the University of Michigan, the district court reiterated the idea that significant advance notice is not a prerequisite, even in hearings that may result in suspension. And that idea was first formulated in the Goss case that we talked about earlier. But from a practical standpoint, as far as planning these student hearings, it typically takes some time to first intake the complaining party's story and identify witnesses, as well as selecting a judging panel and finding a date that's suitable for hearing the subject case. So typically, students are afforded at least a few days, if not weeks, to be made aware of what they're being charged with. Now, I've identified two best practices for providing notice to accused students. The first is always provide the student with a written description of the conduct violation, which includes the time, the date, and the nature of the offense, the range of possible sanctions, and also the procedures for adjudication. This is very important because, as I said before, courts view the student handbook and the procedures that are provided to the student as a contract. And although breaking that contract may not always result in a victory for the accused student, it's important to have a consistent expectation from students when it comes to adjudication of misconduct procedures. Secondly, as the gravity of the offense increases, the amount of time allowed for preparation should increase as well. Obviously, a student who's accused of stealing pencil erasers isn't going to require the same amount of preparation as a more serious offense involving assault or a crime against the person. And again, I'd like to remind everyone that policies and procedures must be in compliance with applicable state and federal laws, but campuses are generally afforded a good deal of flexibility to resolve complaints through whatever means are most effective, efficient, and equitable, given the variety of resources and support available on each campus. I'd have a case study. We'll just read it. Jimmy Chu is a student at State University. He was accused of stealing shoe designs from his roommate, Steve Madden, for a fashion class midterm. It's an all-star student body there. 2 hours prior to the adjudicatory hearing, State University notified Mr. Chu of the allegations against him, the range of possible sanctions, and his appeal rights. So the question is this constitutionally permissible? I'll give you a moment to answer in your head. I'd say yes. Although I would suggest that students are apprised of the charges levied against them days rather than hours in advance, this time frame is determined by the provisions in each student handbook. Federal district courts in at least three of the circuits, have upheld sanctions that were levied against the student who was made aware of the charges at the hearing itself. So there was literally zero advance notice, and upon entering these administrative hearings, the students received the charging document, and that was the only notice they had. But as I talked about briefly before, the practical reality is that usually a few days at least will be required. Okay, let's talk some about fundamental fairness. Touched on this a little. Courts have created a sliding scale to determine the protections that a hearing must provide. And when expulsion is contemplated, due process requires more protections in comparison to more minor offenses. As a general rule, there is no right to cross-examine witnesses in cases involving minor sanctions, but processes should be designed to be fundamentally fair to both the accused and the complaining witness. Typically, both of those parties are going to be students at the institution, and so victim advocate groups have a certain position that these processes should be victim-centered, while attorneys like myself in some instances, and watchdog groups try to make sure that the processes protect the rights of the accused. But we should remember that schools, the main purpose of higher education institutions is to create a safe place for learning and not to adjudicate crimes. So the look and feel of a student hearing is completely different from that in the criminal courtroom. Although the rules of evidence do not apply, I recommend allowing, since the rules of evidence don't apply, it's important that some uniformity is applied so students have realistic and consistent expectations as to rulings that will be made prior to trial. I'll share one story here. I was representing a student at a school here, and the student panel prior to trial ruled that the accused student was not allowed to present evidence that he had been acquitted in a criminal trial for the same underlying conduct, but the panel insisted that the complaining witness could bring evidence that he was charged. And eventually this ruling was overturned, but it's important to realize, although the full protections of a criminal tribunal don't apply, some of the bedrock principles should be crossed over to ensure that fundamental fairness does take place. All right, here's some best practices for fair hearings. As I've said, these hearings should lack the formality of criminal proceedings. At worst, the university or college will expel the student, and it's not as though he or she will be subject to criminal sanction and incarcerated as a result. And so just the fundamental principles behind each are so different that I don't believe institutions should try to mirror criminal court. Most schools do allow legal counsel to provide advice and limited advocacy, but the vast majority of institutions that I surveyed do not allow professional legal counsel to actually advocate during said hearing. Relax the formal evidentiary rules, develop and comply written procedures, and I also recommend recording the proceedings, because in the case that an accused student does bring a lawsuit, it's important to have a clear record of what occurred and to be able to defend the institution. Second case study, Geraldo Rivera is a graduate student at Institute College University. After his test scores dramatically increased, his Spanish professor suspected that he'd been cheating. Based on the university's handbook, Mr. Rivera was presumed guilty and was subsequently found responsible for cheating and suspended for 5 days. On appeal, the review board upheld the decision. Mr. Rivera was not permitted to be present at the appeal hearing. Is this legally permissible? I think the answer to this scenario is also yes, although in criminal cases, defendants are presumed innocent. That requirement is not present in terms of student misconduct hearings at universities and colleges. And neither is the right to be present at appeal. All right, so for the takeaways, the existing legal framework really does provide institutions with a high level of flexibility just because the rights afforded to the accused are so minimal. And the Constitution does not require institutions to provide even significant advance notice or some of the same protections present in criminal cases. This is important because institutions are so different in size, culture, and educational goals that they are free to craft handbooks and procedures that comply with these. Again, we do not recommend that schools attempt to create a mini courtroom, but we do recommend that they offer prompt resolution. And rather than the adversarial nature of criminal proceedings, the general principle behind a student misconduct hearing should be to get to the truth of each matter. And finally, we recommend that schools are intentional in developing their policies and procedures just to make sure that they're not held to task for violating these if litigation does occur.
Right. Thank you, Dan. I'd like to ask everyone now to go ahead and submit your questions if you haven't already done so. We have one question. Well, we've got a number of questions that we've received. We've got one that we're going to address now. I'm going to ask Nelson Wilkinson to read that question and then respond to it.
Yeah, so the question asks, when the law says, and this is referring to the law regarding the notations in the student transcripts, where the law says to remove the notation when the person has been subsequently found to have not committed the violation under the institution's code. It seems to me that a subsequent not guilty verdict under a reasonable doubt standard would not be enough to find that a violation under the student conduct code did not occur when the institution's violation needed only a preponderance of evidence. Is this what the legislation intends? To not remove the notation until the institution determines that it is more likely than not that the student code violation never occurred, perhaps informed by evidence presented by the public court proceeding. So what this is asking, what this is getting to is there is, as most schools are aware, the Department of Education has said that in Title IX adjudications of sexual assault, you should use a preponderance, preponderance of the evidence standard, whereas in a criminal court there is going to be the beyond a reasonable doubt standard. So that leads to the possibility that a student may be found guilty by the school of the sexual assault, or at least it's found it's more likely than not that the student committed the sexual assault. Then the student goes on to be tried in a criminal court and is found not guilty. And the question is, did the legislator intend in those situations for the mark to remain on the notation? And the answer is, I believe, yes, it did. The relevant language says they were found to have committed an offense involving sexual violence under the institution's code, rules, or set of standards, and by extension, that's going to include the Title IX standard. Now, the question goes on to ask, what should the school do if it's found the student guilty under the preponderance of evidence standard, and it goes on to he be found not guilty? Can they then take it off based in part on what happened at that trial? That would depend on what Daniel was just talking about, whether the school has procedures in place for doing that. I think you would raise further Title IX issues if you all of a sudden declared this student not guilty just based on the outcome in a criminal trial. So the short answer to that question is you would not necessarily remove that notation just because they were found not guilty in criminal court. And by the way, whereas the reporting law includes a qualified immunity from defamation for responsible employees, this notation law does not include a qualified immunity for defamation. So it at least, qualified immunity would probably apply in any event, but it certainly leaves open the possibility that these students might try to go after the school for defamation in these kinds of situations.
Okay, great.
Thank you, Nelson. We've got one question for Daniel, and the question is, should student conduct hearings always be closed to the public?
From a best practices standpoint, I believe closing these hearings is probably better for the university or college, simply because you avoid certain interference from the audience, and that's where recording these hearings becomes important, because if you close them off to the public, then it can sometimes turn into a he said, she said as to what happened behind those closed doors. So in the interest of transparency, while still protecting the educational institution's interest in creating a safe learning environment, I think closing the hearings is probably the safer and the better thing to do.
Thank you. There was a question for me which I can answer, and that was, can we get copies of the presentation? And the answer is yes. We will be sending the deck that our speakers use to guide them to everyone that's on the call today and anyone else that might wish a copy. Just contact me if you have got somebody that wasn't on the call today that wants one. Just have them email me and I'll send them to you. Everybody that signed up as participating on the call will automatically receive one. And we're just about out of our time, so In closing, please don't hesitate to contact any of us directly if you have additional questions or if you would like to make suggestions for future topics. Following today's webcast, as I said, we'll be sending links to this presentation, and we hope that you will join us for our future events, including the next webcast, which will be held on September 21st. That's September 21st, and that'll be hosted by Marsh. And then our second annual half-day education seminar, which will be held on October 1st, here in our offices at Williams Mullen. On behalf of Ernst Young, Marsh, Mercer, and Williams Mullen, we thank you for joining us and hope you have a wonderful day and a wonderful weekend.